Did you know that every American over the age of 60 is supposed to have at least 5 documents in place? Yes, you heard that right, exactly 5 documents. And I'm telling you this based on what I've seen in my office over 31 years. Most of you are missing 3 of them right now. And before I say one more word, I need you to listen to this story. My client's name was Patricia Sutherland. She was 71 years old, a retired nurse, and she lived right outside Charlotte in Pineville. Her husband Frank passed away in February of 2022 from a heart attack, if I remember correctly. He was 73 years old. They had been married 47 years. They had 3 children and 7 grandchildren. The kind of marriage you don't see much of anymore these days. 3 weeks after Frank's funeral, Patricia came into our bank. She wanted to transfer some money from the investment account Frank had managed for almost 30 years to pay the property taxes that were due that month into the household account. It was a perfectly normal thing for a wife to do, but she couldn't, because the account was in Frank's name only and there was no durable power of attorney. The will couldn't help her either. For that, it would first have to go through probate. Let me explain probate this way. It's the legal process of administering a person's assets after their death and transferring them to the heirs. And in North Carolina, probate can take anywhere from 8 to 18 months. Now, if you were in Patricia's place, how would you feel? Or what would you do? Patricia Sutherland, 71 years old, the widow of a man she had been married to for nearly half a century, could not access her own family's money for 6 months. She had to borrow from her son just to pay the property taxes. This isn't just an unusual story. Only one missing document caused all of this. And the truth is, Patricia did most things right. She had a will, they had a savings plan. They were what most of you would call good planners. But that one missing document turned the first months of her widowhood into a financial nightmare on top of her grief. If you were born before 1965, I want you to watch this video all the way through, because the chance that you're missing at least one of these 5 documents right now is higher than 60%. Some of you are missing 3 of them. Some of you are missing all 5 and don't even know it. I can say this with certainty because the last document I'm going to talk about, the 5th one, most of you have never even heard the name of. And that's the document that costs families the most. Stay with me until the end, because the last of the 5 documents, the 5th one, is the one most of you have never even heard the name of. And it's the one that costs families the most money. It's a matter that can usually be solved for under $2,000, but when it's not done at all, it sends a $20,000 bill. And do you know who pays that difference? Your children pay it. In the very same weeks they're grieving. That's why I'm asking you to listen carefully. Before we go any further, let me make a quick note. If you're not subscribed to this channel, hit subscribe right now and turn on the bell. Let me tell you why this actually matters. Estate planning laws change all the time. Federal exemptions change. State rules change. And when they change, nobody calls you. Nobody sends you a letter. They change the rule and just assume you already know. And if you haven't taken precautions, it blows up in your face, and they put the responsibility on your shoulders. What I do on this channel is take those changes and translate them into plain English that you can understand and get them to you before they become an expensive problem. The ones who are subscribed find out in time. The ones who aren't usually come back to my channel after the fact, but by then it's too late for them, and I'm sorry about that. Before we begin, I can almost hear you saying, "Who is this guy talking with so much confidence about these subjects?" My name is Tom Bennett. I'm 63 years old. I live here in Charlotte, North Carolina, and for 31 years I worked in the trust department of what used to be BB&T Bank, now Truist. I retired in 2023. For 3 decades, my job was to step in after someone passed away, open the file, sit down with the family, and figure out what they had left behind. And now, after retiring, I came to social media to set the record straight on the misconceptions about inheritance and to put on the table the things you can do for yourself without paying $2,000 or $3,000 to some lawyer. That's why I started this channel. Now, before we go further, I want to be perfectly clear about something. This video is for both of you. If you're a senior living mostly on Social Security and a small pension, this video is for you. If you have a paid-off $500,000 house, a healthy 401k, and a comfortable retirement, this video is also for you. The documents I'm about to walk you through aren't about how much money you have. They're about whether the money you have reaches the people you love, or whether it gets eaten up by courts, fees, lawyers, and the wrong beneficiary forms. I've watched a $90,000 estate get destroyed just the same way as a $900,000 one. The same 5 missing documents, the same outcome. All right, document number 1 is your will. And I want to tell you about Margaret. The names have been changed, but the story is real. Margaret was a retired elementary school teacher from Gastonia, just west of us. She taught 4th grade for 32 years. She was a smart woman, sharper than most of the financial advisors I worked with. In 1991, she came into the bank with her husband Robert, and they prepared a will. It was a proper will. It was signed and filed, and she walked out feeling like she'd checked the last item off her list. Margaret passed away in 2019. Pay attention here. Her will was from 1991. Robert had passed away 5 years before Margaret in 2014. In her will, Margaret had left everything to him, but there was one thing they had forgotten. There was no backup beneficiary. To put it in plain terms so you understand better, there was no plan B. She had never updated the document. So North Carolina's intestacy laws kicked in. Her estate, her house, her savings, her retirement accounts was divided up by a formula she had never seen and never agreed to. The son she hadn't spoken to in over a decade, the one who had drifted away from her, got an equal share with the 2 daughters who had cared for her in her final years. Of course, Margaret wouldn't have wanted that. If she'd known what was going to happen, it would have broken her heart. But the document she signed in 1991 didn't reflect the life she was living in 2019. So how does this apply to the 2 groups I mentioned at the beginning? Listen, if you're a lower income senior, you need to understand this. Modest estates go through intestacy too, and the smaller the estate, the bigger the proportional damage when legal fees and the wrong heirs eat into it. Or if you're in the second group, a comfortable retiree, the dollar amounts add up fast. And that will from 1991 probably doesn't account for the house you bought in 2007 or the IRA you rolled over in 2015. So in either case, when was the last time you looked at your will? If it's been more than 5 years, or if you've had a major life change since then, and a marriage, a divorce, a death in the family, a grandchild born, that document needs to be reviewed. Not one of these days, specifically this year. I'm sure you don't want to end up like Margaret. Let me tell you how to update your will yourself. In most states, including North Carolina, you don't need an attorney for a simple will. You have 2 options. The first is to use ready-made state-specific templates. You can find them on nolo.com for about $40, on LegalZoom for $90 to $150, on Trust and Will for $159. These are forms that do the same job an attorney would charge you $800 to $1,500 for. The second option is completely free. Your state's bar association often publishes a sample will template. Just do a search like North Carolina Sample Will Template. Whichever route you take, 3 things are essential. You will sign the document in front of 2 independent witnesses, you will get it notarized if possible, and you will keep the original in a safe place, a fireproof box or a safe deposit box at the bank. I know you're making this bigger in your head than it needs to be, but if you just take action, it'll only take one afternoon. Document number 2 is the one that surprised Patricia Sutherland and shocks most people. It's called a durable power of attorney. The word durable is the part that matters. An ordinary power of attorney becomes invalid the moment you're incapacitated. The durable one stays active precisely when you can't speak for yourself. And that's exactly when you need it. In November of 2022, during my last year at the bank, a couple came in. They were both in their early 70s. He was a retired engineer, she had been a librarian. A comfortable retirement? They had a nice home in Matthews. But in an unfortunate turn, the husband had a serious stroke. He couldn't communicate. He couldn't sign anything. A week later, the wife came in to access their investment account. She needed to pay the mortgage. The account was in his name only. They had set it up that way decades ago and never thought about it again. She didn't have a durable power of attorney, so she had no authority to act on his behalf. How long do you think it took just to handle that one little transaction? Exactly 4 months. That's how long it took to get a guardianship order through the Mecklenburg County courts. About $6,000 in attorney fees. 2 missed mortgage payments. A hit to her credit that she spent the next year trying to repair. This woman had been that man's wife for 42 years, and she couldn't pay their bills without a judge's signature. Don't try to put your mind at ease by saying this won't happen to me. You'd just be failing to insure yourself out of carelessness. Especially if you're a lower income senior, listen carefully. This is even more critical for you because you don't have a cushion to absorb 4 months of missed bills. If you're a comfortable retiree, you have the cushion, but you also have the bigger accounts that get frozen, the rental properties that need managing, the investments that need decisions made. Without this document, nobody can make those decisions for you. Your spouse can't. Your children can't, not without going to court. Let me tell you how to handle this document for free or very cheap. Every state has its own official durable power of attorney form, and most state bar associations offer this form as a free PDF. Just search Durable Power of Attorney form along with the name of your state. For example, for North Carolina, it's available on nccourts.gov. Download the form, fill it out, and write the name of the person you're giving authority to, your relationship, and which powers you're giving. Then sign it in front of a notary. UPS stores, most banks, and pharmacies offer notary services, and the cost runs from $5 to $25. Some states require 2 witnesses as well. Your state's requirements will be listed at the top of the form. And that's it. Done. You just saved $600 to $1,000 by not going to a lawyer. One warning, after you sign this document, keep the original somewhere safe and give copies to the person you've authorized, your bank, and your primary doctor. Giving a copy to the bank is especially important because if that document isn't in their files, they really can't help you in a crisis. If you've lived through this in your own family, if you've watched someone you love struggle with this problem, share it in the comments. The other people watching this video will learn from your story. And I'm telling you honestly, I read those comments because the other reason I built this channel is for us to connect with each other, people who've been hurt during the estate planning process, and to open up to each other and tell each other what we've been through. Let's move on to the other documents you need to be aware of. Document number 3 is the healthcare directive. Sometimes it's called a living will. And I'm going to get personal here for a minute because I lived through this myself. October 2018, my father had a serious heart condition. He was 81 years old. He had been healthy his whole life. He walked every morning, never smoked, and up until a week before the incident, he was still driving himself to the grocery store. But you can't always predict what fate has written for you. Unexpected things can happen at any moment. And don't forget, you might have 1,000 problems in your life, but the moment one health problem comes along, that becomes the only problem left to think about. My father spent 6 weeks in the intensive care unit at Carolina's Medical Center. And for those 6 weeks, my sister Karen and I could not agree on what to do. Every day, the doctors would come to us and ask the same question. What would your father want? And every day, Karen and I would look at each other and neither of us could give a definite answer. My father had said certain things over the years. Don't put me on machines. I don't want to be kept alive that way. But there was nothing in writing, nothing signed. We made decisions we'll be questioning for the rest of our lives. And sitting in that waiting room, falling out with the sister I love, watching my father in that state, not knowing what he really wanted, that experience nearly tore our family apart. Karen and I didn't really speak for almost 2 years after my father passed. And the reason was a document my father didn't think was important, the healthcare directive, which, without him ever knowing it, put us in a terrible position. A healthcare directive is the document where you put your medical wishes down in writing in advance. Which treatments do you want? Which ones don't you want? Under what conditions? And just as importantly is who speaks on your behalf when you can't speak for yourself. This document doesn't care about your income. Whether you have $1 million or you're getting by on a single Social Security check, it makes no difference. The price of not having this document is paid in something money can't fix. Your family arguing in a hospital waiting room about something they will never find peace with. Tonight, I want you to do one thing for me. Sit down with your spouse or your closest family member and ask one question. Just one. If one of us couldn't speak for ourselves tomorrow, would the other one know what we'd want? If the answer is no, that's the first document you need to handle this month. Let me also tell you how to take care of this one for free, because you don't need to pay a single cent for this document. I'm going to recommend 2 sources. The first is AARP's free advance directive forms. Go to aarp.org, search Advanced Directive Forms by state, and download the form specific to your state. You don't need to be an AARP member. The forms are open to everyone. The second is a simpler source, 5wishes.org. For $5 there, you can get a document that's legally valid in most states and accepted by doctors. The nice thing about 5 Wishes is that it asks more than just medical preferences. It asks questions like, who do I want with me? And how do I want to be remembered after I'm gone? So it really becomes a guide for your family. Whichever you choose, fill out the form, sign it in front of 2 witnesses. Be careful. In most states, family members can't be witnesses, and distribute copies. You can give copies to whoever you want. One to your primary doctor, as I said, and distribute the other copies to the person you've designated as your healthcare proxy, your children, and the hospital you go to most often. Before we move on to document number 4, I'm going to ask one quick thing of you. I'm saying this with honest sincerity. If this video has been useful to you so far, share this video for free with anybody it might help, a brother or sister, an adult child, a friend from church. Because by doing that, you're not just informing yourself about situations they could face too. You're raising your own value in their eyes by sharing this. Document number 4 is the place where I've watched the most money quietly walk out the door. I say walk out, not stolen, not lost. Just sent by law to people the deceased never would have chosen. It's your beneficiary designations. Urgently write this down or repeat it out loud, because most of you have never heard this before. Your beneficiary designations override your will. Say it again. Your beneficiary designations override your will. What you put in your will, your carefully prepared, legally binding will, has no authority over the money in your 401k, on your IRA or your life insurance policy, on your payable on death bank accounts. None of it. Those accounts go to whoever's name is on the beneficiary form. A judge can't change it. Your will can't change it. Nothing can change it, except you sitting down and filling out a new form. In 2017, I sat face to face with a woman in my office. Her husband had just passed away. A good man who'd worked in logistics his whole career and left behind a paid-off house and about $285,000 in his 401k. The woman thought she was going to inherit the 401k. The beneficiary on that form was the man's first wife. They had divorced in 1994. He had never updated the form. 23 years went by. He remarried, built a whole second life, and never thought about that piece of paper again. His first wife, and a woman he hadn't spoken to since the Clinton administration, received $285,000. His wife of 19 years didn't get a single penny from that account. She objected again and again, but she lost, because the form was valid. The law doesn't care about your intentions. It just treats the official paperwork as the truth. Think about it. If you're a lower income senior, your life insurance policy is probably your single most valuable asset. And if that beneficiary form is wrong, your spouse or your children get nothing. If you're a comfortable retiree, multiply that by your 401k, your IRA, your investment account, your payable on death savings, a second life insurance policy nobody's looked at in a decade. I hope you can imagine the kind of amounts we're talking about. A single unupdated form can cost you tens of thousands of dollars, even hundreds of thousands. Right now, I want you to do something. Take out your phone, log into your retirement account, find the beneficiary section. Look at whose name is written there. I'll wait, because this isn't a small problem for you. It's a big one, and a lot of you are completely unaware of it. Do you remember the last time you updated it? If it's been more than 5 years, or if you've had a major life change since then, update it immediately. Not in a month, not in the summer, not when you get back from vacation. At the very least, try to handle it this week. And the best part is you literally don't need to pay anyone a cent to update it. Here's the process. For each account, 401k, IRA, life insurance, individual retirement, payable on death bank account, log into your provider's website. Find the section called Beneficiaries or Beneficiary Designations. All you need to do is fill in your primary beneficiary and absolutely make sure to fill in a contingent beneficiary too. That is, who gets it if your primary beneficiary passes away before you do. But there are two things that are critical here. First, have the beneficiaries' full names, dates of birth, and the last 4 digits of their social security numbers ready. Very few providers will skip asking for that. Second, don't just write one person. Instead of writing my 3 children equally, write each one's name separately and specify percentages, like 33, 33, 34%. Because when you write 3 children equally, if one child passes away before you do, a confusing rule kicks in that varies from state to state. Writing the names and percentages prevents that. All of this takes about 20 minutes per account. You don't need to give an attorney $1,000. No matter how much money you have, this will only take 20 minutes of your time. Now let's get to document number 5. And when you hear about this one, don't say, "What is this?" Because I know it's a document most people have never even heard the name of. And not having it is often the most expensive decision a family ever makes. It's called a revocable living trust. And before I tell you what it does, I need to explain what probate is. Because most people don't really understand what they're dragging their family into when they pass away with just a will. When you pass away with a will, even a perfect, up-to-date, properly witnessed will, your estate has to go through probate. A court validates the will. An executor is appointed. Creditors are notified. Since I worked mostly in North Carolina, I know that here it's a process that can take anywhere from 8 to 18 months. And only after all of that do your beneficiaries get what's left. And it has a cost. Court fees, executor fees, attorney fees if you need one. On a $400,000 estate, you could realistically spend between $12,000 and $22,000 going through this process. And that doesn't even count the cost of a house sitting empty for over a year. In 2021, I watched a family in South Charlotte live through exactly this. Their mother passed away in May. She left them a house worth about $380,000 and some savings. She had a will, but no trust. That house sat empty for 14 months. In the second winter, a pipe burst on the upper floor. The insurance process was complicated because the property technically belonged to the estate, not a person. By the time everything was finally settled, the family had spent roughly $22,000 in fees, repairs, taxes, and unexpected expenses. But the thing people miss is, a properly set up revocable living trust would have largely prevented all of this. A revocable living trust is a legal structure where you transfer your assets, your home, your accounts, your properties, into a trust during your lifetime. You still control everything. You can change it whenever you want. You can dissolve it. Revocable meaning it can be undone, but when you pass away, the assets inside the trust pass directly to your beneficiaries. No probate, no court, no 14-month delay, no $22,000 bill. In North Carolina, the cost of setting one up properly with an estate attorney is generally between $1,500 and $3,000. So how does this hit the two groups? If you're a lower income senior with a modest home and not much else, you may not need a full trust. And I'll talk about that in the bonuses in a minute, because there's a free alternative most people don't know about. If you're a comfortable retiree with a home and other assets, the math is simple. Spend $2,000 now, or leave your family a $22,000 problem to deal with while they're already grieving. In my last years at the bank, a young woman came in to close her father's accounts. The man had been meticulous. The trust was funded. Beneficiary designations were current. Healthcare directive and power of attorney were on file. The woman walked out of my office in 90 minutes. That's the other side of the coin. That's what good planning looks like. Now let's be honest about the trust. Unlike the other 4 documents, I do not recommend the fully DIY route for a trust, and let me explain why. Setting up a trust wrong is worse than not setting one up at all. The biggest trap is this. Most people get a trust document drawn up, sign it, and file it away, but they never actually transfer their assets into the trust. This is called an unfunded trust, and it still has to go through probate, which means you've thrown $2,000 down the drain. You have 3 options depending on your income level. First, if your estate is under $500,000 and there's no complexity to it, online services like Trust and Will, LegalZoom, or Quicken Willmaker will prepare a valid trust package for between $200 and $600. That's about a third of what an attorney would charge. And for most simple families, it's more than enough. Second, if your estate is over $500,000, or if you have multiple properties, a second marriage, or a child with special needs, go to an estate planning attorney. In Charlotte, the typical cost is between $1,500 and $3,500. It sounds expensive, but in exchange, you're saving your family the $20,000 they'd lose in probate. Third, and very few people know this, every state bar association has a program called Lawyer Referral Service, and the first 30-minute consultation is usually somewhere around $25 to $40. In that meeting, you can ask the attorney, does my situation require a trust? Sometimes the answer is no. TOD/POD is enough for you. And that meeting will have just saved you from an unnecessary $2,500 trust. There's one truth I've learned in 31 years, and I'm going to finish by telling it to you. None of these 5 documents are secret. None of them are a door the attorneys are hiding. They're all written in the law, in the forms at the county office, on your bank's website. So why don't most people do them? Because nobody tells them. Attorneys sell you a $2,000 package because that's their business. Bank tellers don't remind you about your beneficiary form because it doesn't earn the bank anything. I'm telling you this because I don't work at the bank anymore. I don't collect a paycheck from anyone. I want my granddaughter Hannah to grow up in a different world. A question for you. In this video, which one made you say, I never thought about that? The will? The beneficiary form? The trust? Write it in the comments. Tell me which document you're going to handle this week. Every comment you write is valuable to me. And when you write one, another family reads it and takes action. In return for all this information, I'm asking just one thing from you. Think of one single person in your life over the age of 60. A mother or father, a sibling, a friend from church, your neighbor. They might be someone getting by on a single Social Security check or a comfortable retiree with a paid-off home. It doesn't matter. I guarantee you that person is missing at least one of these 5 documents right now. Most of the time, 3 of them. Send this video to them. A single share could be more valuable than any gift you'll give them this year, because gifts wear out, but this information will protect their family for years to come. I'm Tom Bennett from Charlotte, North Carolina. Take good care of yourself, and even more importantly, don't forget to spend good time with the people you love.